morning, and thank you everyone for joining us. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. So today we're going to spend some time talking about the options you can consider when you're moving from a visa to a green card. And many of you may actually be on a non-immigrant visa, such as an E2 or an H-1B or a TN, and you may wish to transition to a green card that allows you to live and work permanently in the United States. So we'll be talking a little bit about that today. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different immigration law-related topics. And at the end of this webinar, we'll be sending out a few things to all participants. So first, we will send you a copy of the PowerPoint that has all the information that will be covered in this webinar. We will also be sending you a comprehensive visa guide for all the visa types we'll be discussing today, which is a booklet of information that you can use as a reference. We will also send you a link that you can follow to sign up for the upcoming additional webinars in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button, as we regularly do upload a variety of immigration law related videos, which can be helpful to you. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced lawyers should you wish to discuss your case in more detail. So today we're very lucky to have Ian Scott, who is the founder and president of Scott Legal PC, with a wealth of experience in all of the visa categories we'll be speaking about today, who will be presenting about the various options available to you if you wish to transition from a visa to a green card and what are the main considerations. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Ian.
Great, thank you very much, Jiyae. It's great to be here, and this is a question that we often receive. I do a number of consults. In fact, the last 2 consults that I just did before this webinar, this question came up of how can I move from a visa to a green card? The first thing, before we get into the specific categories, I wanted to just generally talk about how the green card system works in the United States, because it is quite different from a lot of other countries. A lot of other countries have a system where it's a points-based system, and people get points for a number of different things. They get points for speaking the language, they get points for education, they get points for age. The younger you are, the better in terms of the points. They get points for work experience and a number of other factors. And then once they reach a certain number of points, they might be eligible for some type of permanent residency. And that's what a green card is in the United States, permanent residency. And another factor that's often considered is how long you've been in the United States. So, sorry, in the particular country. But unfortunately, in the United States, they don't have a points-based system. Instead of a system that looks at how long you've been in the country and looks at your education and looks at your ability to contribute to the country in terms of work experience or anything else, they just have a list of green card categories, and they say that if you're eligible for them, you can apply. And none of the categories, none of the criteria for any of the categories have anything to do with your ability, the amount of time that you've spent in the United States, or really your old visa that you had, or the visa that you had. And they just really list out the criteria and say that if you can meet the particular criteria, you can apply for the green card, either while you're in the United States or when you're outside of the United States. And broadly speaking, the green card categories, and there are more than what's been listed here, but the green card categories are broken out into family-based green card categories and employment-based green card categories. And within those 2 categories, we have further breakdowns, immediate relative and preference category, and we're going to talk about that when we move to the next slide. But then the employment-based categories those are broken out into 5 different categories, EB1 through EB5. The only one that we're not going to cover today is EB4, which is a religious-based category. Our firm doesn't handle those particular types of cases, but it is something that you can keep in mind in terms of another option for a green card. And again, these are the major categories for green cards. There are others, but these are the 2 major categories: family-based and employment-based. So for family-based, when we look at family-based, they are further broken down into 2 categories. One, immediate relatives. And when we look at immediate relatives, this isn't kind of immediate relatives in the way that you'd think immediate relatives are defined. For example, I think of a sibling as an immediate relative. However, these are defined by immigration law. So you're going to be looking at things like a US citizen marrying someone, or a US citizen child over 21 that wants to sponsor their parents. So they're very defined. And the good thing about the immediate relative category is that they don't have any limits in terms of the number of green cards that can be issued. And this becomes very important because when we move to the other family-based category of preference-based categories, these are broken down into 5 different categories, some subsections as well. But so things like a US citizen that wants to sponsor their sibling, that's a preference-based category. A parent who wants to sponsor a married or unmarried child over 21, that's a preference-based category. Now, the problem with preference-based categories is that they are backlogged. And in some cases, and in many cases, they are extremely backlogged. So when you look at the first category that I talked about, the US citizen sibling that wants to sponsor the brother or sister, that would take 15 years for them to be able to bring their brother or sister to the United States, or if the brother or sister, if they happen to be in the United States on some other type of visa, it would take 15 years for them to get the green card. And when we talk about these backlogs, these same types of backlogs are going to exist in the employment-based category. And really what is happening here is that the government has defined the number of visas that can be issued in each category, and then that's further broken down by country. Now, what happens is that every year, once those limits have been used up, then people go on waiting lists. And sometimes those waiting lists grow and grow and grow. And in the case that I just mentioned, where it's 15 years, that's just what happens when the category has not been available for a long time, and more people get added to the line, and it just takes longer and longer because they can only issue a certain number of visas in a particular year. And as I said, we're going to see this in the employment-based categories as well, and it's particularly problematic these days is because within the family-based categories, if I'm not mistaken, all of the preference-based categories are backlogged for every country. If I'm not mistaken, I'm quite sure about this, but I'm backlogged for every country. And then in the employment-based categories, there is significant backlog for many countries, and then in particular, if you are from India or China, the backlogs might be even more significant. So the other thing I wanted to talk about, and this is going to again apply to the employment-based category, but each of the when you're getting a green card, it's either going to be a 2-step system or a 3-step system. So let's talk about that a little bit. So when someone is getting a green card, there's always going to be the first part of the process, which is a little bit more objective. So if you, under the family-based category, if a US citizen is marrying someone, then the objective part of the process is to prove that it's a bona fide marriage, right? So you're going to have the marriage certificate, and you're going to have a lot of other information that proves that it is a real and legitimate marriage, maybe pictures, photos, or the joint property or leases or things that they signed together, things like that. So that in the family-based context is going to be the I-130 process. So that's step 1. And again, always think about, we won't repeat this as we go through each of the different categories, but think of the employment-based categories as well as always going to have step 1, which is going to look at the more procedural or objective, have they met the requirements in the law? So then after that, those requirements have been met, then the individual is going to do one of 2 things. They're either going to do consular processing, or they're going to file an I-485 petition. And again, that's going to be the same for employment-based categories. And then the other question that's often going to come up if the person's in the United States is whether they're able to file the I-485, because the I-485 is something that can only be filed when you're in the United States. And it gives you benefits because you can actually file employment authorization and travel authorization at the same time. But the problem with the I-485 is that you can only file an I-485 application if you are not subject to one of those backlogs that I just talked about. So, just to review a couple of things, if you're under the immediate relative category, fantastic. You can file an I-485 application all the time if you're in the United States because there are no quotas. But unfortunately, if you're that brother or sister who's waiting to be sponsored for a green card, it's going to be 15 years before you can, even if you happen to be in the US on another visa type for many, many years, it's going to be 15 years before you're able to file an I-485 application. And I went over the benefits of filing the I-485. And then the other option is consular processing. So that's really getting the green card. So they're both, such that you get, that's the procedural part. So they're going to be looking at things like, is the person inadmissible? Do they have crimes that they've committed that make them inadmissible? Do they have, are they inadmissible based on health grounds? So they're all going to be looking at the same things, regardless of whether it's family-based or employment-based. When you're doing consular processing in the I-485 process, they're going to be looking at similar things, but they're definitely more on the procedural part. At that stage, they're not really looking at have you met the underlying requirements. They're going to be looking at have you maintained your status? Are you healthy? And healthy means non-contagious disease like tuberculosis and things like that. And whether or not you have some other form of inadmissibility that's preventing you from entering the United States. Perfect. So I'm going to turn it over to Jiyae to talk through yet another green card category, or another couple of green card categories in the United States.
Sure thing. So let's talk about the EB-1A Extraordinary Ability Green Card. So it is one of the employment-based green card options that we were just talking about. And really, EB-1A is the first priority, the highest priority green card category there is. So the good thing about that is for the EB-1A category, if you can qualify, there is almost no backlog, well, except for certain countries, of course, but for most countries in the world, there is no backlog, and the priority dates are current right now. So what this means is if you can qualify under this category, you can pretty much immediately file your I-485 or file for an immigrant visa and get the green card as soon as you are found eligible. So let's then dig into what types of eligibility criteria there is to qualify under an extraordinary ability green card. So really the standard is that you have reached pretty much the top 1% of your field, and really they're looking for not really only Nobel Prize winners, but really there must be a high volume of evidence that tends to show that you are one of the small percentage who has received national and international acclaim. That is the language in the regulations. That's what they're looking for. Someone who has received recognition for their significant contributions to their particular industry. And really the types of industry can run the gamut. You can be the world's best circus motorcyclist. That's actually one of the cases that were approved. You can also be a world-leading dog agility trainer. That's also based on another approval. So really, it doesn't need to be one particular field, but you can qualify if you can show that you are that top 1% player in your niche. So let's dig into the eligibility requirements. To apply for a green card under the EB-1A category, you must show that you meet at least 3 of the following evidentiary criteria. And those include things like being a member in an association in the field that requires standing achievements, having received a major award that is nationally or internationally recognized, having evidence of published material about you in major media, having invited to judge the work of others, having actually completed the judging, and really to prove that you have made, scientific, scholarly, artistic, or, major contributions in your particular field of endeavor. So you can take a look at the evidentiary criteria here. If you can prove that you can, provide at least 3 of those criterias, you can apply for the green card on your own. Now, there is another step 2, analysis that the government will do, just so that you meet three of the criteria. That's not going to be the end of the whole story. The government will also look at the totality of the evidence and see if the body of the volume and quality of the evidence that is submitted paints you as someone who has actually reached the very, very top of your field. So there is that qualitative analysis as well. So really, this criteria, this category of a green card is not really accessible to the majority of people who are active in a particular field. But if you have reached that level where you have received that national or international acclaim, this is certainly a very, very attractive option for you. So a couple of things to note, advantages. So one advantage is the ability to self-petition. And what does that mean? So usually for an employment-based green card category, you do need a US-based sponsor, US company who will sponsor you with a job offer, basically. And the requirement is that usually the US sponsor, the employer who's offering you that job, needs to go through what is called a labor certification process. And what that means is the employer is required to test the labor market to see if there is a US worker who can basically take your job, who is also minimally qualified for the job. Now, for the EB-1A and for another criteria, which I will also get into, the EB-2NIW, that requirement is exempted. So what that means is you don't need a US job offer. You don't need a US employer to sponsor you. By contrast, you yourself, the foreign national, can be the one who is driving the petition forward. So the ability to self-petition is definitely a remarkable advantage for the EB-1A category. Other considerations for entrepreneurs. One thing to note for entrepreneurs is that you can think of creative ways to meet criteria that traditionally you may have thought that the EB-1A is only for people with PhDs with hundreds of citations in their publications, but actually we have been seeing that the EB-1A is also a very viable category for an outstanding entrepreneur to pursue. So for example, let's talk about critical role, your performance of a leading and critical role in a distinguished organization. And let's say you're the founder of a startup that has received multiple $1 million of funding. You're developing a new technology that has been touted as industry disruptive technology, and you have received a lot of media attention on it. Evidence like that can be used to show towards meeting some of these EB-1A criteria. So the EB-1A actually could be a viable option for many entrepreneurs who are, known as this leading business leader in the industry. So definitely don't be discouraged by the regulatory language that requires outstanding achievements. Definitely talk to a lawyer, and maybe there is a way that we can advocate for you if you're an entrepreneur. Now, the same two-step process applies as Ian just went through. So the first step is filing the I-140, which is the petition to establish your eligibility under the EB-1A criteria. And once you've been approved for the I-140, then you can file the I-45. Now, if your priority dates are current, with regards to that particular category, you can also simultaneously file the I-140 and the I-40. Which means you can file both petitions at the same time. And the I-485 is the application for a green card, as Ian went through in the previous slide. The other option is, of course, to use consular processing if you're not in the United States right now, or if you're driving the whole petition from a foreign country, which is also possible. You can choose consular processing, which means after your I-140 is approved, you will file a DS-260 and sign up for an immigrant visa interview at your home consulate, and you will get the immigrant visa and do the landing in the United States with your immigrant visa and get your green card mailed to your resident. So that's another way you can process But yes, it is a two-step process, so you will need to go through both steps to get the green card in hand. So the second category that I will be discussing is the EB2 NIW, the national interest waiver category. And the national interest waiver is a subset of the EB2 employment-based green card category. And what is special about the NIW is that you do have the ability to self-petition for a green card and not be required to, go through the traditional labor certification process, get a job offer from a U.S. company, have the U.S. company test the U.S. labor market to really prove that there is no one else who has the minimum credentials to basically do the job that you're proposing to do. But if you can qualify under the NIW, you are exempt from that whole process. So you yourself, as a foreign national, can drive forward the petition. So the EB-10IW can be a great category for entrepreneurs, and mostly because of some favorable policy changes that have come down after the publication of Matter of Dinosaur in 2016. The EB-10IW has become a much friendlier and more accessible category for entrepreneurs. So just a few things. Matter of Dinosaur has noted that even an endeavor that is limited to a local or regional area could have national importance. So before Matter of Dinosaur, really a major consideration was geographic scope of your work. But after Matter of Dinosaur, any endeavor in any region can be seen as having national importance as long as it has an outsized impact to the industry, as long as it has a significant impact to a matter of national importance. And a wide variety of things can be found to have national importance. For example, if there is an economically depressed region, right, and a targeted employment area, and if you are running a business that proposes to hire a high number of workers in that particular region population, and if you can get, let's say, a letter of interest from a local government office to support your petition, that kind of evidence can support that your endeavor could have national importance, even if your endeavor, the benefits of your endeavor is geographically limited to that particular region, that locality of the country. So so this has become a very much more versatile and accessible category for a green card for entrepreneurs. Now, the government has also published some policy updates in 2022 that has made it even more accessible for entrepreneurs to try for an NIW. And one of the things is that a variety of evidences can be used now to show that the entrepreneur is well positioned to advance the proposed endeavor. For example, if you have a history of job creation and high growth in revenues and tax revenues, those kinds of evidence can be used to support that an entrepreneur is well positioned to create further growth in the economy, and we can, submit things like tax returns, payroll reports, and things like that to support such well-positioned Hwang, whereas the NIW really used to be more traditionally thought of as a researcher's petition category, with the Google Scholar and 50 citations and things like that. Now the category has really expanded to include, include pathways for entrepreneurs to explore. So the EB2 NIW can definitely be one option that can be very attractive. Now, before we move on, let's definitely look at the threshold considerations to qualify for the EB2 category as a whole. You do need to show either that you have an advanced degree, which is described as a master's degree or above. So for example, if you have an MBA, you could qualify as someone who has an advanced degree, a PhD, an MD, a JD, for example, can also qualify as an advanced degree. Even if you don't have a master's level degree, if you have a bachelor's degree in your field and 5 or more years of progressive work experience in your field after you earned your bachelor's, you can also use that to prove that you have the equivalent of a advanced degree. And you do need to prove that with detailed experience letters from your previous employers, detailing how your duties have changed over the years to include more senior level duties, more, more complicated responsibilities, but provided that you can prove that, you can be considered as someone who has an advanced degree, has the equivalent of an advanced degree. Now, the other way you can meet the EB2 threshold is by showing exceptional ability. Now, I won't go into too much detail on how to prove exceptional ability, but I do want to say that it is a lower standard than extraordinary ability for the EB1A standard that we just talked about. Definitely check out our recordings of other webinars where I go into a lot of detail on how to meet the exceptional ability threshold. But that, yes, that is another way you can meet the threshold requirement for the EB2. All right, so then now I think I will turn it back over to Ian to go over the other employment-based categories.
Great, excellent. Thank you very much, Jiyae. And yeah, so the another area that we see, and we see this in particular with our E2 clients, not the primary on the application, but often their spouse will get a job because with an E2, for example, the spouse can work in the United States without even applying for work authorization. Just with the E2, they can come in and they can start working. And we have seen this often where the spouse gets a job and then the job sponsors them for a green card under the EB2 or EB3 categories. But then also we see people moving to EB2, EB3 from H-1B visas. It's a natural stepping stone. H-1B has its own problems, a lottery, and a very high or low probability of being selected in that lottery. But we do see people moving. But and this is probably one of the most common ways that people move to a green card is a company sponsoring them. And you should keep in mind that under EB2 and EB3, it's quite broad in who can be sponsored. I'm aware of even like nannies being sponsored under EB3 category, right? So it is quite broad. This isn't a category just for professionals. There's specifically an unskilled labor category. Now, and but when we're looking at this, what we're looking at is that the company and individual have to show the government that they cannot find a qualified U.S. worker. And what Jiyae was just talking about for the national interest waiver, that's what's being waived, right? The reason it's called national interest waiver is what is being waived is this labor certification, right? So this labor certification that says basically that, you can't hire this person if there is a qualified U.S. worker available. And what they try to do is set up this very complicated and artificial process to prove that you couldn't find a qualified U.S. worker, which includes posting jobs, real jobs, posting them and having real people apply for them when there was never a job available, and even interviewing them, coming in for an interview, and you're looking for ways to exclude them. So that's generally the overview of what's going on. So before I go into more detail, just one thing to keep in mind is that the EB2 national interest waiver that Jiyae was just talking about. This EB2, it's the same EB2. So before you can even look at this EB2 company sponsoring you for a green card, you still do have to meet those threshold requirements, which were the last thing, the last thing that Jiyae talked about. If not, then maybe you could still apply under EB3 if you didn't meet the threshold, because EB3 doesn't have any of those threshold requirements. So we just said that this is company sponsorship, and really this is a three-step process. So the first part of the process, PERM, and that's all done with the Department of Labor. And the last two parts of the process are done with USCIS, with the Immigration Service. So it really is two separate departments of the government that are handling this application. And the PERM is a complicated, drawn-out process where you first start with the prevailing wage. So you basically just have a job description, and this isn't just any job description, right? This is a job description that has the minimum requirements for the job, right? So it's very, very tailored and important that you're only indicating or including in the job description the minimum requirements, because if you get audited or if the government looks at them and they say, well, why does this job need 10 years of experience, or why does this job need this degree, or whatever it is you put on there, that could be enough to have the firm denied. But so once you complete the job description, you send it to the Department of Labor, and then they come back and they say, well, this is what we think this job should be paid, right? And once then that's called the prevailing wage determination. So once you have the prevailing wage determination back from the Department of Labor, and that could take 6-9 months, but depending on the time, it changes all the time, but it takes a long time for them to just, and it's funny because they're not coming back with a specific wage. There are 4 categories that they have to choose from within each particular job type, and they're just coming back and saying where it is on that 4, which one of the 4 applies to you, right? So, but that takes them 6 months to 9 months to do. And then after that, you can actually start the recruitment process. And it is a real recruitment process where you're posting jobs in multiple places. So you're posting jobs in, you know, like if you're in New York, we post in the New York Times, and we post in other places. And people apply for the job, and once they apply, unless they are obviously not qualified, like if you say the minimum requirement is somebody that has, let's say you're looking for an economist, and the minimum requirement is someone who has an economist degree, and this person doesn't have a degree at all, then you can maybe disqualify them. But generally speaking, in most cases, you would have to interview the person, and you would have to, the person that's interviewing the person would have to keep detailed notes and assess whether or not the person meets the minimum job requirements. If they meet the minimum job requirements, then the process has to stop, right? So it's just, you know, if you get the exact person, you know, if I was hiring a lawyer and I said, okay, well, I want a lawyer with a law degree and then 3 years of immigration experience doing, you know, E2 cases, and then someone applied and they had exactly that, even if I didn't like them, right? Even if I thought that they wouldn't be able to interact well with clients, or I thought that, you know, there's something about their personality I didn't like, it wouldn't matter for the purposes of perm. You would have to stop the process. And then there are all these things you have to look out for. Oh, they're called like triggers. And, you know, if you add a foreign language requirement, that's going to be a big problem often, for obvious reasons. If you add a foreign language requirement, it excludes many people in the workforce, like probably over 90% if you're adding a specific foreign language. And you know, all of these things are going to be audit triggers. And if you know, when you are audited, it's you know, obviously a higher chance of denial. So then after you have done the recruitment process and you fill out the form that you have to file to the Department of Labor for the perm, it's electronic filing. There's a number of smaller requirements in there. There's a waiting period, et cetera. And then the perm might take another 9 months to be approved. And the timing is always going to depend. Like we could look it up right now and say, okay, right now they're doing this, but it's always going to depend. But you know, right, those are reasonable estimates for both the prevailing wage and the perm. And then let's say it comes back approved, and you're like, great, this is fantastic. So now I can file the I-140, right? And the I-140 in these cases, they're a lot easier than the I-140 for NIW or EB1, because you know, it could be as simple as the objective requirement that you're trying to meet is that the, you know, if let's say that we are doing a perm for a nanny, it's that, you know, the person that you are hiring meets the requirements that you had in the job description, right? That's going to be as simple as that. If you're doing it for a professional and you said that the requirements, you know, a degree plus 2 years experience, you would be showing the fact that the person has the degree, and then you would have employment letters indicating that the person had worked for 2 years and had the experience that you actually had in the job description. So and then we talked about this already, that the filing, if you're going to be filing an I-485, because this can be done through consular processing, but it can also be done through USCIS. And a lot of the time, whether the choice sometimes will depend on the individual. Like sometimes if someone has an H-1B, the H-1B allows them to travel, so they might you know, opt for the I-485 because they still have the flexibility of traveling with the H-1B and not having to wait. But other visa categories, like if someone has a TN or if they have an O or some other visa category, and we've had this before, a case I recall where it was someone to his national interest waiver, and the person has really, really strong case. But it was not possible to file the I-140 and the I-485 concurrently, because you have, if you file an I-485 and you don't have an H-1B, you do have to wait in the United States until your travel authorization has been approved. Like you can't leave. And we have clients that just, it's not possible for them to spend months in the United States. Like it could be 9 months in the United States without leaving. So then they might opt for consular processing, but it really, really depends. Now, and you know, one other good thing with these petitions is that if you have children under 21 and a spouse, then they can join in that process. So in the example I started with, where you have the primary, that's an E2 visa holder, and he or she is married, and the spouse gets a sponsorship, and they have kids, then all of them get the green card, right? Everyone gets the green card. So it's that's a great thing with this. You just have to kids up to age 21. So you have to kind of monitor as your kids get older. But everyone would get the green card. Okay, so another area where we see people moving to a green card, and here we see a lot of people on E2 moving to EB5, but also other categories we see them moving to EB5. And before we get into the specifics, there are kind of two ways of two categories of EB5. One is regional center, which is more someone's applying for or someone wants a more passive form of investment. So let's say that a hotel chain is building a hotel and they want to raise $100 million, and then they go through this EB5 program, and they get a number of investors to invest $800,000, and then they raise the money, and then they have met the requirements to be able to be a regional center so that the individuals can get green cards. So that's kind of one way, right? And those are more passive investors. And those you might see people on other types of visas like H-1B or TN or some visas like that, employment-based visas like that. But then you have the other category where they're direct EB5 investments, where someone has started a business or wants to start a business and wants to invest the money to do that. And we'll talk about the other requirements, the job creation requirements, but they want kind of control over their own destiny. And there we see more people with E2 doing that. We do more people that move from E2 to EB5. One other thing I mentioned before we move into the specifics of EB5 is that we are just touching on these categories, EB5, NIW, EB1, but we have separate webinars on each of them, right? So we have a separate webinar just on EB5 where we go through the details of EB5, and separate webinars just on NIW where we go through the details. So this is more focused on moving from a visa to a green card. But for each of these, you could go to our YouTube channel and see that we have webinars on each of these, or sign up for a live webinar because we have them often, at least a couple of them a week. So EB5 requires that you invest either 800,000 or 1,050,000 in a new commercial enterprise. But new commercial enterprise, even though it's a regulatory term and has new in the regulatory term or phrase, it's really an enterprise that started after 1990. So it can be an quite old enterprise. And what determines whether it's 800,000 or 1,050,000 is where the business is located. So if it's located in a targeted employment area, where the target employment area is going to be an area where the unemployment rate is 1.5 times the national average, then you qualify for the 800,000. And if it's not, then you would have the higher investment amount. And then the other area that qualifies for the $800,000 is a rural area. And the other good thing about if you do invest in a rural area, the government has prioritized those, and they can be processed quite quickly. They say within 6 months. So that's something to keep in mind. The investment that can be included, we have to kind of talk about this in context of E2 versus EB5. The E2 and EB5, they're similar in terms of they're both investor visas, but they do have different requirements. And in E2, for example, you can get an E2 with purchasing a business. You can get an E2 with little documentation related to source of funds. But the EB5 is not like that. So EB5 is very focused on the investment creating the job. So that's the reason that purchasing a business doesn't work for EB5, because the money just goes to the seller. So that doesn't work for EB5 because the government says that's not job creation. And the analysis for EB5, the source of funds analysis, it really is more like an audit, right? So that's the source of funds analysis. We maybe had 1 or 2 cases where it's been a simple, straightforward analysis, but I think once we had a lawsuit that someone won that from a major company, and that was an easy source of funds. But other than that, they're quite complicated, because they will, even if the money comes from savings from a job in the US, they're going to want to see the accumulation of the funds over time, and of course the tax returns as well. If the money came from the sale of the property, they would want details of where you got the money to buy the property. They don't care that the property was purchased a long time ago. Doesn't matter. They want details on how you got the money to do that. And so it is quite an onerous requirement, even though the regulations, the E2 and EB5 regulations, define the requirement in a similar manner. The EB5 is quite difficult. Another difference between the E2 and EB5 is EB5 doesn't have any nationality requirement. It doesn't have any percentage ownership requirement. So E2, of course, does, where we have to the investment has to be made by someone from a national from the treaty country. And the company has to be 50% owned by a national and treaty country, whereas EB5 doesn't, and also it can be a fractional percentage. There's no specific amount that anyone has to own, although it can't be a loan or anything like that. It does have to be some type of equity, whether it's limited partnership unit, share membership unit, or something like that. The other big part of EB5 is that, the other important thing I think to mention with this EB5 in particular, if you're moving from E2, is the situation of the investment has to be from outside the company, and the individual investing has to be in possession and control of the fund. So if you get a gift, you can't just take the gift and have, let's say a parent was giving you a gift. The parent can't take the gift and send it directly to the regional center or send it directly to the company. They have to send it to the child's bank account, personal bank account, and then the child would have to send the money from the personal bank account to the regional center or the investment. And then they're quite strict about that. They've actually denied cases, not any of our cases, because we know that that's the law, but they've actually denied cases for that, where a parent didn't want the money to go to the children's personal bank account because they're afraid they can spend it or something. So they sent the money directly to the regional center, and the case is denied because they said the child didn't ever have direct possession and control of the funds. So, but the other big thing to keep in mind is the investment can't be retained earnings. So if you have an E2 case, and let's say E2 business, and let's say that the E2 business made $2 million in 1 year, the revenue, and then there was $1 million in profit. And then, you kept the money in retained earnings, and the next year you said, okay, well, I spent it. I'm spending this $1 million, and then now after I spend it, I'm going to apply for an EB5. That doesn't work because retained earnings doesn't count, right? Like it's if you want to pay yourself the retained earnings and then invest in some other business, could work. It could even work if you paid yourself, the money went outside the company and you invested in the same business, but we don't recommend that. We definitely advise you just to start a new business and invest. So that's something to keep in mind. So the other big part of the EB5 program is job creation. So unlike E2 says, jobs, but it doesn't say how many. EB5 says the number, it's 10 full-time jobs, and keep in mind, it's full-time jobs, not part-time jobs, and they're 10 jobs for US citizens and green card holders. So we strongly recommend if someone is on an E2 and they are thinking of the EB5, that they subscribe to E-Verify to make sure that the people actually are eligible to work in the United States, because we have had that before where people have given employers false documentation. And when you're applying to remove the conditions, even sometimes when you're applying for the EB5, the initial petition, the I-526, the government will point that out. It will include, I-9s or information on people that they've already hired, and they'll, point out that this person's documents are false, or that they were not able to verify them. So that obviously can be a big problem. Then the process again, and this is a 3-step process. I think I mentioned that some are a 2-step process, some are a 3-step process, and I only talked about the 2-step process. So let me talk about the 3-step process here. So we have the I-526 is the first step of the process. That's showing that you've invested the 800,000 or 150, and that you can have the ability to create the jobs. Then again, the same thing, I-485 or consular processing. The great thing about the new rules with respect to EB5 is since March of 2022, the I-485 can now be filed concurrently, which is great because especially with long waits, because it takes probably a good 4 years before they'll adjudicate an I-526 petition. And then the third step of the process, and this happens in this petition, but also in the family-based petition I talked about earlier, where a U.S. citizen marries someone, that it's a removal of conditions. So sometimes, not all petitions have this, or few petitions have this, but a removal of petitions, which basically says, you know, we're going to give you a conditional green card for 2 years, and now that you have the conditional green card, we're going to remove the conditions once you show us that you, in this case, that you've actually created the 10 full-time jobs. Perfect. And just very, very quickly, just kind of putting these on the screen so you know that we talked, there are other green card options. We have at least once a year, we have someone who wins, one of our clients, whether it's an E2 client or other client that wins the diversity lottery. So that's, something that if you're eligible, you should, and you want a green card, you should definitely apply. That comes up, that should be coming up soon in October, I think, is the next time you can apply, and then they run the lottery in May. But it's definitely a real thing, and we, as I said, we have clients that have won it. And then there are these humanitarian-based green cards, VAWA, and others, some for helping police solve a crime, and they're not asylum. They're not all listed here, but there's something to consider as well. And then we can always hope for immigration reform. That seems to be something that certainly hasn't been addressed in the last several years. And then, the final slide just is really, when you are moving from a visa to a green card, I think that you have to be conscious of, which visa is it that I have, and how is it that I'm going to maintain status while I'm going through the process? Because some of these processes are quite long, in particular EB-5, but even the perm process and sometimes depending on the weights of the national interest waiver. So you have to kind of be planning out exactly how is it that you're going to renew what you have? Are you able to renew what you have? And making sure that you have contingency plans if something happens as well, because sometimes an employer can decide to change their minds, and there can be layoffs and things like that. So the other thing is, we talked about this as well, travel considerations and visa expiration dates. Like when you're planning the whole process, like sometimes you're not, if you're filing the I-45, for example, you may not be able to travel, so you have to kind of consider that. But then also, when you're planning the process of getting a green card, you want to look at how much time you have left on your current visa. So if you have a TN, for example, only have 1 year left, it may not be a great time to start the green card process, to start filing an I-140, because you may have to renew your TN, right? And if you have a pending I-140, it might be more difficult to renew the TN. So maybe better idea, wait 6 months, renew the TN, and then start the visa process after you have done that. The dual intent considerations, I think that, one thing we always have to consider, there's some visas that are dual intent. So all that means is that you're permitted to have the intent to file an I-485 petition when you enter the United States. So keep in mind, the intent that they're talking about here is not the intent to get a green card. It's completely fine to have a visa, a non-immigrant visa, and intend to get a green card. What is not okay is not to have an intent to adjust status in the United States when you enter on a non-immigrant visa that is not a dual intent. So, so if you have an H-1B, no problem, you can enter with the intent to adjust status. If you have a TN, you can't enter with the intent to adjust status. However, you could have a TN and go back and forth. Let's say that we have clients that are doing this, and they have an EB-5 petition approved, and they can go back and forth, and the government knows that they're getting a green card, but they've elected for consular processing, and that's what they plan on doing. So all of these things are unfortunately not straightforward. They are complicated. So you should always be working in conjunction with your immigration lawyer, because you can always have a rogue agent that says and does anything he or she wants to do at the border. But the rules, if you have the rules explained to you, and then maybe descriptions of the types of things that might trigger unfortunate events, then it can be helpful, I think. We have lots of people who do parallel green card strategies, whether it's, we've got a few EB-5 petitions approved, and then they've been in the States for a while and they met US citizens and married. And then that's a better petition for reasons that, the reason is that it's, you can apply, if a US citizen marries someone, the person can apply for a citizenship within 3 years. And then also rather than 5 years, and then also the green card process has sorry, the EB-5 process still is a long way after you have your I-526 approval. You have to do the removal of conditions of I-829, and that can be extensive because even those petitions are taking 4 to 5 years. So you're in the system for a good 10 years or longer. And really, the planning is key with respect to any of these petitions.
All right, so now we can go over some questions that may have come up. We have a couple that came down, so I guess we can just answer them in turn. So first question from an attendee. Do you have any thoughts on how the EB2 National Interest Waiver Preference category might progress in fiscal year 2025? If a person with an approved I-140 EB2 NIW enters the US on a TN visa, can they simply change from consular processing and request adjustment of status after moving to the US? The third question is, if one applies under EB1 and the category is current, does that mean they will not be able to enter the US on a TN visa anymore? So I guess, yeah, I can take some of those questions. So regarding the movement of the priority dates, usually every October, once the new batch of visas become available, we do expect that there will be forward movement. Now, unfortunately, we can't really predict how much they will move forward. We do know that a new batch of visa is available, so it will move a little bit. But actually, I don't think we don't really foresee that the category will become current anytime soon for the EB2, just because the category has been backlogged for so long and the wait time is so long. We've had clients wait over a year until their priorities become current, and I don't think this will correct very drastically anytime soon. So I mean, it is definitely something to keep an eye on. But the number of NIW petitions and the number of approvals are always increasing, and it has increased a lot in 2023. So I do think that the backlog will unfortunately continue. And with regards to the questions regarding entering on TN after you have the I-140 approved, as a general matter, if you say that you will consular process, but later you change your mind and you have a valid, a non-immigrant status in the US, it is possible to just, change to adjustment of status, and you can do that. You can file the I-485 and you can, send a quick message to, the NVC telling them that you intend to you intend to adjust status, as opposed to consular processing. That is definitely possible. But regard to the third question, definitely set up a consultation with us. We can look at your, specific case and see, what are the risks there. Any other questions we can look at before we end? I'm a Canadian currently in the US on a second consecutive TN status. If I marry a US citizen, would the next step only to be to file the I-485 adjustment of status? Do you want to take this question, Ian?
Sure. So I'm a Canadian currently in the US on my second study. 2 years. Oh, okay. Yeah. So if you marry a US citizen, then a couple of things you have to keep in mind, right? So one, if you file an adjustment of status application, you shouldn't have the intent to file it when you enter on TN, when you enter with a TN, right? So sometimes, even though they've removed the detail from the regulations, they used to kind of apply a 90-day test where they said that if you have, do something within a 90-day period, then we will presume X, Y, and Z. But I think that they removed it, and I think it's for good reason they removed it, because it's not, the timing isn't really that relevant. It's just that, but let's say that someone comes to the US and let's say that they roll up to the border with a moving truck and then enter the US, and the officer notes that they're rolled up in a moving truck, and then they come to the US and they're in some non-immigrant status, and then they adjust status, 5 days after they get into the United States. And then maybe the border, as they're doing their I-485 interview, there's all this stuff posted on Facebook related to, a pending wedding and with things like that. It can be a problem. Like there is, keep in mind for that particular category, because I'm speaking a little generally, for the marrying a US citizen, you have less of an issue because there's some case law, and it might be state specific though, but there's some case law that tends to suggest that an individual can in fact actually still adjust status when they're marrying a US citizen. However, that doesn't mean they can misrepresent at the border, right? Because I think that some of the things you have to be wary of is that you enter and then the officer starts asking you a bunch of questions, and then you're not honest with them, right? And then you come in and then you say, well, I'm going to rely on those cases that say that I was allowed to have the intent. But if you didn't tell the officer that you had that intent based on them asking a bunch of questions, then it could come back to haunt you because while you are permitted to enter and adjust status when you are marrying a US citizen, there's all these exceptions with respect to when you're marrying a US citizen. You just have to be careful, because if you are asked questions and you misrepresented when you entered, that could be an issue. So, but to answer your question, I think that filing the adjustment status application is your next step, and then you would just kind of want to make sure that there's nothing that is going to lead an officer or anyone to believe that you misrepresented when you entered.
All right, so another question about the TEA, what regions can qualify for the lower investment amount of 800,000? And that really depends on the published employment rates, and I think there is a calculation that you need to do. But we'll be happy to help you with that if you're interested. Definitely schedule a consultation, and we'll help you identify those regions.
Yeah,
and with
you
regard,
can email us. Yeah, they can email us for the fee for our fees. We can email us, and we'll be happy to send you our engagement letter.
All right, so I think that is all of the questions that came down today. Thank you, Ian, for sharing your expertise, and thank you everyone. For joining us today, and hope everyone has a great day.
Perfect. Thank you. All right, take care. Bye.